Hello, good evening, and thanks again for another edition of Ideas Exchange. Tonight, our focus will be on Asen North, what I see as an ensuing controversy that will go down in our history books. First, watch this.
After the elections. And so clearly, we want to be thankful to the court, the judge, and to say that we are most grateful for the ruling given to us today because we have achieved what we wanted to achieve. So you notice that Mr. Chikata's supplementary affidavit was supposed to give to the court a plethora of conduct that the Attorney General has displayed, which conduct does not sit well with our legal profession. And you notice that he quoted the Legal Profession Act, which does not allow for comments such as what the Attorney General engaged in. His conduct was an issue before the court. And I'm happy the senior Charles Chikata took him to the cleaners, and you all saw it.
Is that the end of it for you, or you intend to take some steps with regards to the concerns that you have?
And senior has indicated that his main concern is to bring the conduct of the Attorney General before the court. We don't intend to take any further action. But if this becomes too much, I think we will advise ourselves. Evening, he's going back. The people of Asen North should prepare to receive him. They are going. There's going to be a big welcome from the hands of the government that is persecuting him. So his entry into Asen North this night will be a big welcome to him.
Well, so that was Abraham Amaleba. He's the Director of Legal Affairs of the NDC. He was speaking after today's court proceedings. At least lawyer Chachi Chikata tried his best and was able to secure the permission that he was seeking for Jechikwesin. And we are now aware that Jechikwesin will be in the constituency to campaign until, I think, June 27th, after the by-elections. And then if the case is called subsequently, he would come. Tonight, my guest in the studio with me will be speaking to all these issues. Earlier, I'm sure you saw the picture of Chachi Chikata, who was in court, and he's being mobbed by some supporters of the NDC, and you can see jubilation galore because yesterday, when the proceedings started and people got to know that it's been adjourned today, there were lots of commentaries on social media, to be specific, and people used harsh words. But this development in Asen North will go down in history books. And a number of questions come to mind. I've tabulated a number of them. First of all, political interests and overriding national interests come to play as far as Asen North is concerned. I'm sure in the course of our conversation, you will begin to appreciate some of these critical issues that we must watch carefully in order not to dent the image of our courts or our governance structures, the executive, even parliament, as an institution. Again, institutions, their true independence, issues about fairness, the role of our courts, questionable rulings, winning trust in our state institutions, our constitution, the critical role of the apex court. I'm talking about Supreme Court with regards to controversies over interpretations of clauses or articles in our constitution, which many people find a bit interesting. Now, all this is happening, and many say it is needless, because as we speak, we know one person is dead in Asen North because of what is happening ahead of the by-election. We also know that one NPP official, actually is the Bono regional chairman of the NPP. He is, as we speak, in critical condition at the Kolebu Teaching Hospital. The helicopter there went to the constituency to flow him out because he was involved in an accident at Akunfode in the Asin North District while he was campaigning, and he has been airlifted to Kolebu Teaching Hospital. Many people are injured and some are hospitalized at Asin Fosu and then Asin Praso Hospital. This happened when a vehicle involving the NDC also sustained accident, and then some people got injured. One person died, and we know the picture you see on the screen is the former President John Mahama visiting some of the patients at the Asin Praso and Asin Fosu hospitals. Now, before I introduce my guest, I want you to reflect on a tape I pulled from the archives. It was a concern raised by then minority leader Haruna Idrisu, and it was about the same Jechi Kwesin case, which brings our mind to why this particular seat or this particular by-election may be a do-or-die affair for both government and the NDC. Why Parliament becomes a subject of interest. First, you listen to Haruna Idrisu, and then I will introduce my guest.
Addressing you on some developments from the Cape Coast High Court, which seeks to suggest a possible by-election in the Asin North constituency and the potential of our colleague, the Honorable Kwesin Gachi, being denied his legitimate role as an elected representative of the Asin North constituency, which election he won outright as a citizen born and bred in that community, but for some time had to sojourn in Canada. He subsequently, as I understand, renounced his citizenship, expressed so far back 2019, got his certificate at least before the elections. Before the elections. His renunciation certificate was before the elections. We in the minority remain unshaken. We are confident that it is our seat, it will remain our seat. Our first is to use the same legal processes and legal forum and opportunities available within the Constitution. We will contest the ruling. The judge erred both in law and in fact. It's a travesty of justice. But what is worrying, we don't want to believe that the courts of Ghana have been captured and that the courts of Ghana have become forums being used surreptitiously to tilt the balance of power. We are equal, 137, 137. What is happening is the courts now being used to tilt the balance of power and to weaken time-tested historical notion of checks and balances.
So that was then minority leader Haruna Idrisu, and he made this statement on the 21st of July 2021. And since then, a lot of developments have been witnessed in this country. My guest tonight is a legal practitioner. He's the MP for South Dai, a member of the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. Standing and then the Public Accounts Committee, Standing on Orders Committee. Yeah. You'll be a big man.
Oh, it's small.
Does it come with kudi?
No, not at all. It rather comes with a lot of work.
Because you came earlier, and I noticed that for the next hour after your arrival, you had a big book and you were just reading.
Yes.
And I was asking myself,
this book.
Yes. That's a constitutional and administrative law of Ghana, Professor Raymond Atuguba.
Yes.
Do you sleep? Do you have social life? Do you have fun?
Well, every good lawyer every seasoned practitioner go through what I go through. Every serious lawyer worth his salt to tell you this, because for you to get ready for tomorrow, you need to sit through the night before to read your briefs, countering arguments, advancing supplementary arguments, and all that. So, if in the legal profession, if you get to a stage, you hardly sleep.
You become used to.
Every lawyer, every good lawyer gets about, on the average, 3 hours of sleep.
Wow.
Yes.
So how do you marry this with your parliamentary duties?
It makes it worse. It makes it worse. So because when I was entering parliament, when I was campaigning and seeking to get elected in 2016, I had only one grey beard. Yeah, and when I checked my beard in the mirror, I'd been playing with just one.
One.
Single hanging, very dark, beard. But it's all grey now. It's all grey now, and you don't sleep.
Wow.
If you want to be effective, if you want to do your work well and be noticed, you have to read. So in addition to the law, I don't want to go stale. I don't want my law to be stale. I want to be up and updated. I want to be very current. I want to be able to educate people on legal matters, constitutional law, and all that. So you need to read, and that's the law alone.
Well,
then,
Roxanne,
when it comes to politics, to be effective on the floor, you must understand the issues. And some of the documents that come to Parliament are like twice this. You need to read to understand the issues.
I remember some time ago I came to your end and you gave me the Auditor General's report, which was so voluminous like this. I still have it. The Roxanne Dafamakpo, in fact, Roxanne Nelson Dafamakpo Eche Kwame Dafamakpo is my guest tonight. We are looking at Asen North. Now, if you listen to the former minority leader, he raised some critical questions. He mentioned the court, he mentioned the executive, he mentioned parliament, a hung parliament, and of course, perceptions that perhaps the courts are being used to tilt the balance of power. As we speak, there are some critical bills that may be tabled before Parliament. One is the CIEC seeks to introduce. That is why this Asen North case is quite interesting. But before I start this conversation with Roxanne Dafamakpo, beginning from just the proceedings that we are witnessing in the courts, i.e. today, the decision to revise the day-by-day sentence, I want you to listen to this tape I pulled from the archives again about a complaint by Roxanne Dafamakpo.
Pointed about this particular adjournment because the matter has been in abeyance for some time. We have rather pushed for the panel to be constituted for this matter to be gone into. We were duly notified. We came to court. A series of other cases have also been adjourned. We got the indication that the court will sit and go into this matter. However brief that will be, only for us to be told that it's adjourned to next week, Wednesday. No date has been, no reason has been assigned, just like that. And it appears to be the trend these days. In fact, in my own case, regarding the status of the two first ladies, the two first ladies and the second ladies issue, this will be the 15th adjournment from last year, April. And it is not fair when you make litigation more economically painful for plaintiffs who come to court and other parties who are also hauled before court. So we want the court, as much as we revere the court, we want them to assign reasons, cogent reasons why some of these adjournments are done in some of these important cases. My brother has been injuncted from performing his public functions until a matter is finally determined. His constituents are deprived of his services as an elected representative of them.
So that was Roxanne Dafamakpo, and that was sometime early this year. And you were complaining. In that particular tape, I saw Jechi question by you. Now, if you reflect on these concerns you raised in the past, and what we are witnessing today, what comes to mind?
Thank you very much. Good evening to yourself, my brother. We've come a long way, from our days in Kivas. Yes, ATLFM.
I tell you, we've done a lot.
Yes.
When I tell people you are my schoolmate, we're in the same senior group,
doing student politics,
and it was fun at that time.
Yes.
And you are an MP. I'm still gossiping.
You are not gossiping. you are a mugu in the media.
Of course, thank you,
and thank you for doing so well in the media. And good evening to our viewers, and of course my people in South Nine.
Right,
Peki, Pali, Beve and Tongo people. Look, like I still call him leader, like leader said, Haruna Idrisu said, the NPP is actually using the judiciary to tilt power in parliament. I say this without mincing words. I say this with a lot of pain, but it ought to be said. Because look, there's a certain jurisprudence regarding litigating parliamentary election disputes in this country, stretching all the way back to 1670. I can recall, because if you recall cases like Awuno Williams versus Birema in the 1670, if you recall cases like ex parte Hawa Yakubu, if you recall cases like Yebua versus J.H. Mensah, that's about 1997-98. You recall cases like Inri parliamentary petition, that is Zakaria versus Nimakan. You recall cases like Sumala Bill, that's number 1, number 2. And of course, my own senior, Collins Dauda, in ex parte Collins Dauda, that's the ex parte, the registrar of the High Court, Sunyani, and all that. In all these cases, the Supreme Court has been very clear. Or the High Court that has the original jurisdiction in the parliamentary election petition has been very clear that you do not injunct an elected representative of the people until the matter is determined by a court of competent jurisdiction. Because you see, there's a presumption of regularity of that election. And that presumption of regularity is given effect in Article 64(2) of the Constitution. And that is in respect of the election of the president. Let me read. You know, this discussion, it will anchor a lot more on law. So let me read this so that viewers can follow us and understand exactly what I mean by presumption of regularity. 64(2), where are you? Okay. This is what it says. 64(1). Will give the preamble, the intro. Right. The validity of the election of the president may be challenged only by a citizen of Ghana, who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of the election, in respect of which the petition is presented. This is what 2 says. 2 says, a declaration by the Supreme Court that the election of the president is not valid shall be without prejudice to anything done by the president before the declaration. In other words, until an elected and sworn in into office of a president is determined otherwise by the Supreme Court, everything he does
is legitimate.
So indeed, you cannot stop him from working, from performing the functions of office of the President of the Republic of Ghana. That is why when President Mahama was challenged in 2012-2013, the court did not injunct him from carrying out the functions of office of the President of the Republic of Ghana. Because then who would have acted? You understand me? Because an injunction does not mean absence. An injunction does not mean absence. So where the Constitution says in the absence of the president, the vice president will act, an injuncted president doesn't mean he's not present. is present. He's been stopped from working. So the vice president cannot act. So applying this presumption of regularity of election of the representatives of the people into public office, no, of the president, applying this doctrine, mutatis mutandis, that's the way we put it in law, then it means that where an election of a member of parliament is challenged, like in all the cases, litany of cases I've listed, the court ought not to injunct the person from performing his functions of office until it is otherwise declared. That is why when the election is declared null and void, it is the seat that is declared vacant. It means the fact that the Constitution says you must declare the seat vacant means there is an occupant of the seat. You understand you understand the philosophy that
I get the premise of the Constitution. Yes, what went into
that is what the spirit and the letter of the Constitution. For the seat, look, for me, if I get off from this seat, it means it becomes vacant. So when they use the expression vacant for the clerk of parliament who will write to the electoral commission and say that a seat has been declared vacant, it means prior there was an occupant.
Which will also be referenced to a court ruling which would have concluded the case.
No, by whatever means, because the scenarios for which a seat will be declared as vacant in parliament have been listed by the Constitution itself. When there's death, when there's resignation, when there's cross carpet, and of course, when the election is challenged and the court rules that the election that has been challenged, it's indeed valid, and so that election ought to be scrapped, declared null and void for a new one to be held.
So what is
the point I'm making is that the work of the MP until that time of the declaration of invalidity of that election cannot be invalidated.
So that is with reference to the High Court ruling that Haruna spoke to. So how do we compare that to the Supreme Court's interpretation of the law on when he should have renounced or received?
No, that is where the Haruna's position that the government is resorting to the judiciary to tilt power in parliament dovetails. You understand?
I do.
It means that for the first time the court has departed from the established principle and indeed from the constitutional provision which is of mutatis mutandis application to the election of members of parliament, that you cannot injunct a member of parliament. And, in fact, an elected member, whether even an assemblyman, if somebody decides to challenge the election of an assemblyman, you cannot injunct him until that election petition is properly adjudicated upon and pronounced by a court of law. But we have experience in this country where an elected representative of the people who has been sworn in parliament and has been performing his functions of office as a member of parliament was asked by the court to stay away.
For close to 2 years.
Yes.
Now, it happened.
Yes.
I would have some related question to this subsequently, but I just want to look at that specific case and what eventually led to the Supreme Court deciding that his election is null and void and that his name and records must be expunged from your Hansard or whatever record you have in Parliament.
Again, that pronouncement by the court is with all due respect, a journey to nothing. It's a journey to nowhere. Because in law, there are certain orders that we call them non-executable orders. The court gave an order that cannot be executed. Technically speaking.
Which the speaker sought to express by telling them to show them the way.
There's also, we have a practice in the courts where the court makes directives or judgments or rulings that are ambiguous. You, as an affected party, can apply for clarification. But here is the case: Parliament was not a party to the matter. It was the Attorney General that was a party. And my brother Jachikwesi, if he's not interested in going back for clarification, then the ruling of the court will hang in its ambiguous state. Because it is not possible, it is not feasible, it is not plausible for Parliament to go back into time and delete, as it were, expunge, as it were, every activity that Honorable Jachikwesi engaged in, including debates on the floor, including his votes that led to the passage of budgets in this country, passage of bills, including his votes against the passage of certain loans,
including the election of the Speaker of Parliament,
and including
the swearing in of the president. They played a role.
Exactly.
Now, but can somebody, I'm just asking, out of ignorance, maybe somebody wake up today and go to court?
No, that is why. That is why. You see, the court would embarrass you. They will tell you that that is not what they intended.
So why did they make that declaration and give those directives to
the court was in haste to make pronouncements on the matter.
Now, when you say haste,
yes, sometimes you can be in haste, and I say this advisedly. They were in a hurry to make pronouncements, so they use words and phraseologies, the effect of which will lead to an absurdity, because they know, as the laws, as the apex court, that our constitution forbids the retroactive effect of court rulings and legislation. It is the orders of the court and the effect of our legislations are for going forward only purposes.
What could trigger this? Because as an apex court, yes, where you have such learned men at such high position, they'll be making decisions that are fraught with some ambiguities, which may even come back to haunt them.
You see, that pronouncement was needless. Was totally needless and avoidable. Once they made a determination that the election in question was not validly held, or Kwesi's participation was invalid, that ended it. Because the plaintiff was asking for a declarative order. Mm-hmm. In making a declarative order, there's no need to make consequential orders. Because one of the key jurisdictions of the court is to interpret the Constitution. In fact, that's the primary duty of the court, is to interpret the Constitution. So once you have placed an interpretation on the constitutional provision that was invoked before you, that ended it. Everybody else will comply with your directive, with your declaration. Just declare, say that it is null and void. That ends it. Everybody will take cognizance of that and act accordingly. There was no need for you to make further directions. The Parliament should take steps. That is why the Speaker said, well, we've gone through our standing orders. There's no procedure for us to expunge records of a member. And Kwesi, mind you, Kwesi is not the first MP who had been elected, whose election has been challenged in a court of law and has been declared to be invalid, and therefore a by-election ought to be held. Does it mean that by the application of this directive, the elections of all other MPs that have been challenged, taken out of Parliament, their records will be expunged? Including, for instance, the first MP for, I think, Ayawaso Wogon, Rebecca Adote, who was challenged by Amu, and for nearly 4 years they were in court. And by the time the court decision had come, the term of that Parliament had come to an end, would all her efforts in Parliament would have been exposed. So it was really an empty directive.
Well, my guest tonight is Roxanne Nelson Ete Dafamapo. I won't add the last one. Is my guest. We are talking about our Senate. We are looking at some interesting happenings in our courts. We'll be taking a short break, but before that, I want to ask this question. We have three key arms of government.
Yes.
As for the media, we are just tagging along. The executive, the judiciary, and parliament. Yeah. Now, if it was such that precedents and the actions of courts, i.e. the High Court's ruling that Jachikwesi should no longer participate in proceedings, from where you sit, as a legal practitioner was inappropriate, could Parliament have acted differently to bring them to order as an institution protecting its integrity and its sanctity?
You see, Parliament doesn't have to do anything in this case, because we have made it clear that the directive that issued from the court, we cannot comply. There's no procedure for us to comply. So it's non-executable in nature and character. So somehow there are...
No, I was making reference to the initial High Court ruling, which Haruna complained about, that the decision to ask him not to participate in proceedings until the case is heard was inappropriate. Is that not what
yes, but that is the issue I have raised. That's why I've said that in all the long cases or judicial cases that I have cited, the court has never asked those MPs not to perform their duties. You are actually saying that an MP shouldn't perform his constitutional functions of office. That is what that directive will mean. That is how come somehow, even though the High Court couldn't insist on that order, the Supreme Court somehow, they got the Supreme Court somehow to do it. You recall,
and I recall that
yes.
your colleagues, the minority,
yes.
had issues
yes.
with the ruling on that particular case.
Yes.
Some are still in a fix. They are not too sure whether the argument that at the time he was filing his nomination and at the time he was being elected, and whether the renunciation certificate came in timeously, according to the Supreme Court. Now, that issue is still baffling people who think the Supreme Court may have done the right thing.
You see, the Supreme Court didn't do the right thing at all. And I'll tell you why. Me, if I file, if the Electoral Commission opens nomination, and I file my nomination on the ticket of the NDC, it is a mere declaration of intention.
Right.
I am only saying that I have an intention to contest as an MP on the ticket of the National Democratic Congress. I can get some other great opportunity tomorrow, and I'll decline that opportunity to contest the parliamentary seat. So until you are elected, it is a mere declaration of intention. Indeed, within the constitutional provision that determines the eligibility of a person contesting for parliamentary seat or parliamentary elections, there's this provision of being of sound mind. You know of that?
I know.
So if on the 7th of December you are elected by the people popularly, and you are waiting swearing in a month later, and a medical report is issued by a certified medical doctor that you are not of sound mind, the Electoral Commission has the power to decline you.
So why is it that the Electoral Commission could not stand by its own understanding of the directives that's carried over the years and sat on the fence?
It's not even a directive. It's not a directive. It's a regulation.
So why didn't it speak to the issue that
the Electoral Commission can only be a witness in the matter? Because I filed my nominations. They have interpreted their regulations to say that between the filing and the time of the elections, they are satisfied with my compliance with the constitutional requirement that at the time of my election, before I become a member, I am sworn in as a member of parliament elected by the people. I do not owe allegiance to any other country. So if after filing my nomination, I have demonstrated before the Electoral Commission, pursuant to a petition filed before them, that I have denounced my allegiance to another country, say Togo, and they are satisfied and they claim me and are contested, that is in compliance with the law. That is why when you decided not to, when you withdraw, as we term it in our parlance, if you withdraw as a candidate, because when you file, you are a candidate, you are not elected. The Constitution says to become a member of parliament. When do you become a member of parliament? When you are sworn in. Thank you. So to become a member of parliament, there are eligibility criteria. So even when I am elected by the people and there are evidence that I am not eligible, I can be denied.
And so you will not be sworn
in. You may not be sworn in.
Well, we'll leave this controversy here. We'll be taking a short break.
So the Supreme Court got it wrong.
When we come back, we'll be looking at the proceedings, i.e. daily hearings, what it has triggered, what it means to the minority, and of course, the bigger picture, Parliament, hung Parliament, and what many fear could be plans to make sure that certain bills are pushed through at all costs. And that is why Assin North is becoming do or die. Again, in this conversation, we'll be going to Assin North. We understand that after today's proceedings, as Amaliba said, James Jechikwesin, if he went according to plan, should be in the constituency. We'll be dashing there maybe in the next 20 minutes from this time and speak to one of the NDC national communication officers to find out if he has arrived and how he was received. We'll be back after this short break.
Welcome to the Royal Dazzle Event Center. With a lush and well-maintained lawn and garden, you are assured of the best serene and comfortable atmosphere to organize all your family and social events. Live the royal moments here with friends and family. The hosting capacity of 600 to 800 people makes Royal Dazzle the most versatile of places to host weddings, parties, funerals, conferences, concerts, and many more. Create your memories with us. Call us for inquiries on 055-814-8585 or 024-620-2144, or pass by and speak to any of our friendly staff. Locate us at Myjohn, close to Zoom Lion headquarters. Royal Dazzle Event Center, creating memories.
Welcome back. This is Ideas Exchange. Tonight we are looking at Assin North, the legal issues, the controversies, suspicions, what it means to Parliament. And my guest is Roxanne Nelson Ete Dafamakbo. He's the MP for South Dai and a member of the Parliament's Constitutional, Legal and Parliamentary, is a member Parliamentary Affairs Committee and the Standing Orders Committee and Public Accounts Committee. I got it right.
Yes.
Now, so I've monitored a lot of controversy or conversation on social media. Did it come to you as a surprise when the Attorney General, for example, was pushing the court to hear the case on daily basis? Because I heard him use the word he can go to jail. His decision to go and contest Assin North is his personal issue. It's he used the word responsibility.
It's a selfish quest.
A selfish quest and so
yes.
on. How did it come to you?
It didn't come to me as a surprise because I have picked bits and pieces of information that they intended to indeed do him in. And so for a matter such as this to have been filed sometime in 2000, the last time I say it was 2 years, but I got the accurate date that it was filed sometime February or January 2022. And so it's about 18 months old at the court. And you have been calling your witness. In fact, prosecution is still on its first prosecution witness. And it's been going on for some time, only for you to suddenly say that there should be day-by-day hearing. That is what shocks the conscience of everyone. It's not that the NDC finds it difficult that a criminal matter should be heard day by day. In fact, it will lead to expeditious hearing. So as lawyers, sometimes when you get that, you are rather happy. It affects how you prepare and return to court the next day. But right. you are happy so that you can quickly deal with it. But we are looking at the peculiar circumstances and the timing of the by-election date as well as the fixing of the day-to-day hearing. I am told by himself, the Honorable Neil Lantevandapoint, that in 2004, he suffered similarly. In fact, when he was being prosecuted, his case was heard day by day for 2 months continuously.
2 months?
2 months in this country. In 2004.
Under Kufuor?
Yes.
Then.
And I was shocked. He likes to call me Eche. He said, Eche, in La Cabo. 2 months. So as soon as he decided not to contest the Ododo seat, the day-by-day hearing ceased. So there's always a political undertone to these things. That is why my leader Haruna Iddrisu got it right when he said that the government is having recourse to the judiciary to tilt power. Look, what is happening in Parliament is about numbers game. You have heard the Electoral Commission, even though they came to Parliament to engage Parliament at the committee level, subsidiary legislation, special budget,
which you belong to,
which I belong to, constitutional and subsidiary. I'm a permanent friend. Constitutional legal, I'm a member. Special budget, I'm a friend. And also the committee of the whole on their proposed CI to make Ghana card the sole document for registration. Parliament vehemently, in the first time in a long time, in a resolution rejected that proposal. They are still out there calling the bluff of Parliament, actually making public statements that it is only the Ghana card that will be used for the EC registration, when you have not brought the legislation to Parliament.
What does it mean to you?
What it means is that they are standing on something. When a blind man says that I will stone you, you must be certain that he has his foot or hand on a stone.
As not.
So you must watch your direction. Otherwise, once he gets the direction right, he will deal with you. So the Electoral Commission must have been giving some signal to keep talking in the manner that they continue to do. Because they are calling the bluff of Speaker. They are calling the bluff of Parliament. That even though you have engaged us and issued a directive that in addition to the Ghana card, include other documents such as the guarantee system and the passport, they are adamant. They say as for the EC, as for them, they haven't heard what Parliament has said. So they will continue with the original proposal. So they are rubbishing Parliament as an organ of state regarding our stance. What are they relying on? Perhaps as enough will give them an additional.
But some have said that Parliament has created this. Because just recently, somebody made reference to the South African Parliament that the number of those in the minority are smaller, but they are able to hold Parliament.
Sometimes don't listen to this roadside pedestrian talk.
Okay.
Because we function within a certain constitutional architecture. Our constitution is not the same as the South African constitution. Our governance structures are not the same. Our parliament is, to some extent, incapable in dealing with matters the way people think we should. You understand? Because of the constitutional architecture. The constitution says that it is the Electoral Commission pursuant to Article 51 that will bring regulations to us, constitutional instrument, to regulate the act setting, that's the constitutional, that's Act 45 setting it up, and then the Electoral Commission Act setting it up. Now, Supreme Court has gone ahead to say that where a regulation is brought to Parliament, we are incapable of tinkering with it once it's gazetted. So what we do is to be doing pre-laying. Pre-laying is that before you come and lay the document, come and let's vet it. Which is not regular. It is not underscored by any legislation. So in these matters, we are so incapable as to stopping it, but we can stampede. That we can be grandstanding. That if you don't listen to our suggestions and incorporate them, we will not let you lay it. But you know how the house works. The business of the house is led by the majority leader, who is a member of the party forming government. So if the party forming government is aligned with the Electoral Commission in terms of this thinking, then we have a problem. It means that they will look for an opportunity. The day they get it, then they will do a kangaroo laying. That is laying in at the blind side of everyone. So people must understand we can't have recourse to cattlers and cudgels. But we can make our points known that we have cautioned the Electoral Commission that the path they want to take will lead to a path of damnation and crisis and social upheaval. If they want to insist on using... Atefa has just opened premium offices all over the country. People are paying
250 thereabouts.
No, 280 Ghana cedis to get a Ghana card. And when they make a mistake in spelling your name, he says you should pay 110 Ghana cedis for that to be correct.
What does it mean to your constituents?
What it means to my constituency is that I must ferry my people from Ajebui, Bongbonikofe, Jemeni, Agodake, Atokloku, Chanakpe, to Dugan, Ahon, Kaira, Chinu, Sanga, Anyensu, Pekijaka, Vetile, Chame, Afeviofe, Blengu, Jogbati, Wudome, Agbate, Ajokwe, Todome, Peibome, Chokokofe, Chate, Agodake, Kaira, Golovime, Abuichita, Peve, Chokokofe, Wudome, Vegbe, Wawasi Camp, Anyensu, Sanga, Chinu, and ferry them to who? At my cost.
And pay.
Feed them, because when they go, the queue will be long. Feed them and pay 280 Ghana cedis per applicant. And where, because the data input officer is in a hurry to input data names and commits a clerical error, I will again be levied 110 Ghana cedis for that clerical error to be corrected.
But if Parliament is constrained to some extent by the constitutional
I want to add this so that you appreciate the point. What Atefa and his NIA have done effectively is that they have stopped the district registration. And they have channeled the traffic to the premium centers. For people to be traveling like 80 kilometers to the regional centers to get registered.
Now, you see,
it's such a pain.
I've had series
when in the past 6 years we have given him in excess of 1.1 billion Ghana cedis to do this work regularly. Yet he claims that he hasn't got money to buy machines, to recruit staff, to get proper offices. What did he do with 1 billion Ghana cedis?
No, you see, I've had reports, and of course I've seen complaints come to me about secret busing of people to specific locations, even in Accra, where people have been quietly registered through the support of those who are interested in those operations. Now, after that, they are coming to your areas. But the concern I have is that if Parliament is constrained by the issues you just raised, then it means your party is sleeping because you complain and you are not doing anything.
Eric, what do you want us to do? Do you want us to go and beat Atefa? We've summoned Atefa to Parliament. He came to Parliament to speak highfalutin sounding English and complain that he has no money. He should be giving money. He could print 500,000 cards that he has registered but cannot print. He's been giving the money. He claims he's printed the cards. Ask him whether he's done the distribution. The next we have heard is that he's opening offices to get money from our people. So, look, this is a man that was part of Nana Addo's election petition lawyers in 2012 and 13.
See,
so you cannot expect him to act fairly. That is what I've been telling my party.
If you can't expect him to act fairly, and you sit, I know For example,
we haven't sat.
The leadership of your party has raised the issue. So what is the leadership of your party doing?
We expect you, the media people, to amplify this matter. That what Atifa is doing will lead to crisis. And these are people who tell you that they believe in democracy. They don't believe in democracy. They don't want to create a fair playing field for all of us. They want to do things that will favor their political ideology so that they can perpetuate themselves in power. Otherwise, there's no basis for Professor Atifa to do what he's doing.
Now, when you go to the constituencies, what are the narratives? Do you feel that anger, desperation?
I can show you messages. People are organizing, so I come and take them to Ho. They don't have the 280 Ghana. They are saying, MP, we are organizing, so please come and take us to Ho so that we can go and register.
Do you subscribe to those who fear that you may just be grumbling and MPP will have its way to?
We are not grumbling. We are not grumbling. The difficulty that we face as a party is that it appears we are speaking about the issues. There are discerning people in this country who have refused to listen to the issues we are raising.
And it's drifting us gradually.
There may be fire one day. Because where we are getting to, it's a clear determination by the NPP with its appointees in some state institutions that are playing very critical role in link with our electoral fortunes to do the bidding of the NPP. You know, I am in court in respect of the appointment of Dr. Ahainyo.
Those two officials.
I couldn't get any evidence against the woman. So I am only going against Dr. Ahainyo.
Okay. The Bono regional NPP official at the EC.
Yes.
What's the latest on that case?
I think it's been served. Because to have a card-bearing member of a party person being a commissioner at the Electoral Commission, I don't know the role that he will be assigned in our electoral processes. That cannot be the original intent of the framers of the Constitution. Because look, Professor Atifa is not a neutral person. He's not. He's an MPP to the core. In fact, he's more MPP than some people in Parliament and elsewhere. So, as a party, we need to focus on what he's doing and know that he's hurting our interests as a political party in the impending political processes that will be coming up.
Did NDC MPs or NDC, as a party, you don't speak for the party, but of course, you're a key member of the party.
I speak for the party. If once I'm here speaking, okay, I'm speaking on behalf of the party.
Have you learned lessons from what happened in 2020, i.e., prior to the 2020 election registration? All kinds of protests, everything was done, yet the EC or NIA had its way, which may have gone against you, and then we are marching gradually towards preparation for the 2024 elections, and here we are, and we are still repeating what we have witnessed in the past.
I have been drawing attention to that. For instance, in the proposed CI that the EC is seeking to bring, if you go to their regulation, I think regulation 33, they intend to repeal the existing CIs that gave birth to the voters register that we have. And they will have the power to compile the new voters register. When I raised the matter, they say, "Oh, it's a standard provision." I said, "No way," but that is where the hidden power is. If you allow such a provision to sit, as soon as that CI passes, the Electoral Commission can say that, well, the voters register that we have now, we have members on it who use maybe passports to register, who use vouching to register. And so because they use the guarantee system and passport to register, the voters register is polluted. So they must compile a new voters register using only Ghana card. So, and Atifa in doing this, didn't open the premium centers at a go. He opened it in Ashanti and ensured that...
No, it was open in Ashanti, Eastern and Western region.
Yes, so let me make my point.
To be specific.
So he opened it in Ashanti, added Eastern region, and when the pressure
and
was...
those are MPP strongholds.
Yes, and when the pressure was mounting from their people in Takra, because, you know, they control secondary Takra, they is their MPs. So they decided to open a third one there and run this for like 6 months before opening other centers, including who? It is, look at the Ketu South population. How do you expect the Fagomashi, for instance, to transport the people from Aflau, Denu, Agbozuma, Nogoku to go to Ho and register at 280 Ghana cities? Where are we going to get the money?
What can be done differently to make sure NIA is put under pressure to go back to the elections?
We have asked him. In fact, if you check the Fees and Charges Act, which we passed recently, it allows him to charge some of these levies. But the law mandates him to actually undertake the district registrations and actually go to the people in zones. When the people have grouped themselves, if for instance, in South Dine, if we have Pekin Secondary School, if they can get some numbers of people who have age and are not registrants and are ready, the law says that the NIA should move to this school, register the people at a modicum fee. He's not doing that. For instance, I can organize my people in Gemini Market or Kweve Market and ask him to come on a market day like Thursday and register the people in Gemini for me. Or go to Kweve on a Friday, market day, and ask him to come and register because we will get numbers. He's not implementing those
How do you react to those who are becoming fed up and are saying that the NDC has become a weak party?
We are not a weak party at all. We are law-abiding, corporate governance conscious party. We want to do things properly. You see, we cannot have recourse to guns and cutlasses and all.
But the narrative suggested that if it peaks, anything can happen.
Yes, and that is what we call social upheaval. When you put water on fire and it heats up, it boils. When it boils, that's not the end. It can boil over. That is why we have the English expression, things are boiling over. Things are boiling. It hasn't tipped over yet. But they should be careful that it doesn't boil over, because the optics are not good. Every single state institution appears to be aligned with the NPP. You just can't believe it. Everybody wants to do things to appeal to the NPP to perpetuate themselves in power. But the sovereignty of this nation resides in the people. And they determine where executive power lies.
My guest is Roxanne Nelson Etse Dafamapo, MP for South Dai. I told you we'll be going to Asen North briefly. And so I'm told Akogan, who is a Deputy National Communications Officer, is joining us via Zoom. Good evening, sir. Thanks for your time.
Good evening.
Yeah, Mr. Gan, I heard you. Good evening. First of all, you seem to be in a car. I can imagine the stress on your face. How is Asen North like?
Eric, first of all, let me thank you for this opportunity, and also to say that the court ruling today has given us a breath of life, some joy, and a spirited Asen North. I nearly said Okaiku North, my constituency. And seriously, we were on the campaign trail, so we were not by the radio. So in a community that we got into, we saw people shouting. That was around 1 o'clock, thereabout. And then they brought the news to us that this is the information that they've heard, and their uncle is not going to be appearing in court every day and is going to be in court only on this Friday. And they are very happy that he's going to have the opportunity to campaign. And another significant thing is that an old woman said that, and let me try a very bad fancy. He said that in Kunimzia, Yanwafa, Jokwe Sinedzi, Yenimde, and then I watch Susiakoto Abana, Jokwe Sin Bidzin Kudim, Nankunim Yami Yanaza, most Motanyen. I hope that I quoted her right. But in effect, what he said was that the success that their uncle has chalked, that success is going to see us a week today. And they are so sure that it's also going to reflect in the polls next week, Tuesday. And that is the joy. Yes, as I speak to you, he's on his way to Akonfede. And he's just still following through the programs that was planned or arranged for him. And that was that always, because we thought that he's going to go to court only every day. And in fact, because of that, we have organized a program from 6 o'clock to 11 p.m. each evening. So that the moment he returns from the court, he will go to a minimum of 5 communities. And irrespective of the information that we had from the courts today, we are still following through with that program. So as we speak to you, as I speak to you, he's on his way to Akonfede, where I just passed to the next community. And if you look at the number of people on the road, not at the event, too, at the roadside in Akonfede, waiting to lead him to the community for them to have the community engagement, you realize that this is a man who the people know and feel that he is coming to serve their needs. And
let me ask the last question. Now, I know the NDC has raised issues about security. We know the police is deploying over 800 men and women. We are told military personnel are there. You had some concerns. What's the latest, and how are you preparing yourself to ensure we don't have Ayawaso West Wagon kind of conflict?
First of all, we don't have issues with the security on the main road who are doing checks in people's cars and all those things. These things are expected. However, there are people who are dressed in military and listening or following the, how they call it, security experts, and the level of discipline that you expect from military officers. And what is happening in the various communities, especially where you have NDC strongholds. You have people who are, who meet people from the farms. One out for Abaman, who do you vote for? If you say you vote for MPP, they say, oh, okay, that's fine, we'll protect you. But the NDC people will deal with them. If such people, and I stand to be corrected with all respect, because the military is an institution that we must all respect and will not run them down. So some of us have a funny feeling that this may not be regular military officers, maybe hoodlums who have been dressed in military attire and all those things. So I believe that the military should be concerned. And as we have deployed some police officers, the military should be interested in those people who are also engaging in such acts, because it may get to a time that to test whether they are proper military people or they are not, they may be beaten. And the moment they are beaten, we will know whether they are regular military or they are not regular military. We pray that we don't get to that point, because people are also getting angry. And the military should be interested in some of these things ahead of the elections. If not, okay, at least we have cautioned them enough.
Okay, so Akugan, I told you earlier we were trying to get you long before we managed. I'm told because of your movement, the line kept dropping. So we'll leave it here. I'm sure tomorrow the production team will come to you either on Jabwase or in the subsequent bulletins to give us updates on your activities on the ground.
Thank you very much.
Dafama says his regards to you. He's watching you. He's my guest in the studio.
I'll see you tomorrow.
Wonderful, wonderful. Lawyer, I salute you and then thank you for
I'll join you guys tomorrow.
Wow, wonderful.
Okay.
And Eric, if you give me the opportunity,
briefly.
I want to really thank the members of parliament, the 136. They have a very short message for the people of Asin North. And their message is that they had 137. Through the works of the court, they have lost one. And they are all here to make sure that they secure their last one and take them back to. And that message is resonating with the people, and they appreciate what the MPs are doing. And you see, Asin North is a scattered, or let's say, they are a cosmopolitan area with people coming from different backgrounds, as in they speak different languages,
right.
And then they come from different regions.
Many of them
and
are
when
settlers.
they come,
right?
Yes, they look out for their own. They look out for their constituents, and they go to them and speak to them. And it's been wonderful.
All right. Thank you. Unfortunately, I have to drive you out to go and continue your job. And so that was Akugan, Deputy National Communications Officer of the NDC, speaking to us through Zoom or via Zoom to help us appreciate the Chikwesin's return to the constituency. Now, let's be wrapping up. First of all, I picked information that all of you are going. And I think I spoke to Kujeto Ablakwa earlier this afternoon, and he told me he's moving to the constituency. You are joining them tomorrow. Yes. Now, for Parliament as an institution, how are some of your members reacting either on the quiet or in open about this case against one of your own?
Nobody is happy. No, that is why you are scandalized to hear your colleague MP on the other side insisting that Kwesin will go to jail, as if the court has already written a ruling seeking to convict him, which they are privy to. Look, Kwesin's case is not on all fours with Sakande. Those who are making those extraneous efforts, it is not correct. The facts of Sakande are materially different from the facts in the Kwesin's case. Sakande, even after having been sworn in as a member of parliament, was still in possession of 3 passports. The Burkinabe passport, the UK passport, as well as the Ghanaian passport. Not one allegiance, 2. Kwesin, at the time of his election, was a Ghanaian, properly so-called, owed no allegiance to any country. So, they should look, the facts are distinguishable. The case, Sakande's case, and Kwesin's case are distinguishable.
Well, I wish we could have some 40 more minutes to continue this conversation, because I'm enjoying him and I'm appreciating the law and I am understanding the controversies better. I believe you did. This program will be repeated tomorrow between 1 and 2 p.m. And as I told you, XYZ Broadcasting will be bringing you updates on whatever is happening at Asin North. And of course, on the day of the election, we'll be giving you all-day reportage on the ground. My name is Ahainyo. My guest was Roxanne Nelson Ete Dafama. He's a legal practitioner, MP South Dai, member of the Constitutional Legal Parliamentary Affairs Committee of Parliament, a member of the Standing Orders Committee, Public Accounts Committee, and also a friend of several other committees. He was my schoolmate. We did many things together at the University of Cape Coast from 1997 to 2000.
Yeah, 97 to 2000. Who were the Millennium graduates?
And you remember the day we blocked the University of Cape Coast, that's Cape Coast Takrady Road. We blocked it because of
80
grading point. Charlie, you be hard, man. Or me too, I'll be hard.
You'll be hard. You'll be tough not.
I tell you, that's how we end the program. Maybe in future I'll be an MP and I'll be a lawyer like him. So enjoy the program. We thank our producers for giving us extra time to wrap up on this. Next week, We'll come again with another interesting topic. Good night.